good to be with everyone here on today's webinar. We've got another jam-packed program. We're going to cover some brief COVID updates with me. We're going to cover USERRA. We're going to cover workers' compensation and COVID-related issues, some business insurance issues, as well as some emerging corporate issues that we think are of general interest to everybody here today. So again, a lot to cover. Let me just mention real quick on the survey. If you can take just 2 minutes at the end of the program to complete the survey, it's very helpful for us to get that feedback. Like I've said before, we want to make sure that we're delivering content that is valuable to you, and that feedback that you can give us is absolutely critical. We usually get about a 10% response rate, it seems, but I'd like to see if we can't kick that up today a little bit. So now's a good time as we hopefully continue to pivot away from COVID-related issues. We want to know what's of interest to you. So again, please let us know. Please complete the survey. And thank you in advance for that. Okay, so just a quick update on COVID. I want to give you some of the statistics that you'll see on the next slide. We continue to see, and these are national statistics here, we continue to see positive development. The last time I was with you all was on March 7th. I gave you the same slide then. And at that time, we were looking at a 7-day average of about 36,000 cases and 63,000 current cases happening at that time. We've seen that trend and the positive trend continue. The number of overall cases has diminished significantly, as well as the 7-day average, where we're looking at just 23,000 cases right now. Of course, that stands in stark contrast with the other data that I have in there at the peak, which was January 10th. So again, continued good news on that front. I think the other major COVID development that we saw last week was the confirmed end of the emergency designation that had triggered activation of your New York HERO Act plans. Easy for me to say. Again, this was an important development. As you know, these plans have been in effect for several months as we saw the Delta and Omicron spikes amid the COVID pandemic. So what do we do now? Well, it felt good to cross that off with some red ink on here, just personally to put this behind us. But keep in mind, all this means is that our plans are deactivated, right? And pending another activation, we're going to have to take them off the shelf and reactivate them. Hopefully never, but potentially so. So the law is still on the books. We are still obligated to have these HERO Act plans. As a matter of policy, we're still required to have them incorporated into our handbook, but they're just not activated now. In anticipation of your questions, you may still have it. To those of you who are required to conduct employee screening under your HERO Act plan, right, we can now stop doing that under the HERO Act. So good news there, more positive developments. Okay, it is my pleasure to welcome Mara Afzali. Mara is going to talk to us about an important piece of law that's on the books on the federal side of things, USERRA. So without further ado, Mara, thanks for joining us. Good to have you with us today.
Thanks for having me, Andy. And yeah, so I'm going to talk about USERRA. And why am I here talking about it? Well, I'm a litigation attorney in Bond's Albany office. But I'm also a reservist in the Army JAG Corps in the legal command out of Schenectady, New York. And so USERRA is something that's both of interest to me in my civilian capacity and also in my role as a reservist. And so we're just going to briefly, of course, not have time to go too in depth into USERRA, but I want to give you an overview of what it is, its purpose, and a little bit about what it covers. So what is USERRA? As Andy noted, it's a federal law that protects civilian employment and reemployment of service members. There's also, just as a little asterisk, the New York military law. So anytime you're looking at compliance with USERRA, you also want to make sure that you're complying with the New York or other relevant state level military law requirements, which essentially mirror, but you want to make sure you're addressing any distinctions. So, but we're going to be addressing USERRA for purposes of today. So why do we have USERRA? So USERRA was passed and is implemented in order to both address some of the common problems that come up around service particularly in the reserve and the guard, right, where you have service members who are also serving in their civilian capacity and in their civilian employment. And obviously issues come up around that. And so we want to both address those issues, but also in doing so to encourage and support military service. We want to make sure discrimination, we're avoiding discrimination, both in the discrimination statutes, but also through USERRA, and also minimizing the disadvantages of serving and the impact on civilian careers, and minimizing disruption. And I highlight here, both for service members and for employers, right? So there was a study that was done in 2007 by Congress, which found that there was just some pretty, striking numbers of, 11,000 service members denied reemployment and 22,000 with losing seniority pay or other benefits. And again, it's important because as reservists and guardsmen, it's critical to the national defense and readiness of our country for us to be able to find a way for this to work. I think a little known fact, for example, for the Army soldiers, about half of our Army service members come from the reserve and guard. And so in order for the regular Army to do their job, they need to be able to rely on us. And in order for us to do our job, we need to be able to work with our employers. So, it can be difficult enough to get called away, but you also need to know that you're going to have that stability. And on the other side, the employers deserve to know that they have a reliable workforce and they can meet the needs of their organizations. And so the goal is to strike a balance, set reasonable expectations and obligations on both ends. So on the next slide, we're going to go over who it covers on the employer side. It's covering both public and private employers, foreign employers working within the US, and this is regardless of size. So pretty much you can assume that it covers you by default. So as an employer, you're going to want to make sure that you're complying with USERRA. On the employee side, we're talking about primarily, like I said, reservists and National Guard, guardsmen, and this is when those individuals are activated either federally, right, by the president, or on the state side by the governor. And interestingly, I put January 2021 in there because before that, USERRA itself, while I noted there was state laws covering that did cover guardsmen, it was in fact in January 2021 around the COVID activations that USERRA was expanded to cover guardsmen when they were activated on the state side. It also includes when we're called away for training, for drills, for special assignments, or even medical examinations or to attend military funerals. And this is both service that's voluntarily undertaken and involuntary. So sometimes, right, we're told what we need to do, and other times there's certain requirements you have to hit at some point. And so you find the most convenient times and you volunteer and raise your hand to do it. So on the next slide, we're going to go over some of the specifics. So the employee rights and responsibilities, the right to be free from discrimination and retaliation. And this is a motivating factor test for those familiar with other discrimination laws. It's also the right to have health insurance and pension plan coverage, though not paid for by the employer, but access to and the ability to get back on when you return from service. Prompt reemployment to the position the employee would have attained in terms of seniority, status, and pay. And that's commonly referred to as the elevator principle. So if the employee would have been moving up that escalator, you're going to work with them to get them back where they would have been. And that's subject to 5 criteria. So the service member needs to meet in order to have those protections covered. So the leave is obviously for a service purpose as opposed to something else. There's advance notice provided to the employer with some exceptions due to military necessity in terms of security clearance and or reasonableness in terms of the ability that service member may have to be able to provide notice or that they themselves had notice. There's 5 years or less cumulative military service with that particular employer. There's no dishonorable discharge or punitive conditions, and there's a timely request made for reemployment. And that's a really key one for employers because it puts the onus on us as service members to make sure that when we come back, we're timely notifying our employers of our request to be reemployed. And there's a chart that kind of lays out, depending on the length of service, how much time we have upon return from an active duty period of service to make that request. In terms of the employer rights and responsibilities, the requirement to notify employees of their rights under USERRA, provide training and skills as required upon return of the service member. And again, those protections kind of come back from those 5 criteria that the service member needs to meet. And on the next slide, we're going to go over quickly enforcement. So when there's an allegation of a violation under USERRA, that's made either via complaint to the Department of Labor, Veterans Employment and Training Service, and that leads to an investigation, a possible mediation, or a referral to the DOJ to represent that individual in a civil action. And alternatively, the employee can just go ahead and seek legal counsel and file a civil action directly. There's no exhaustion requirements. And what they're looking at recovering is going to be a compliance order to reinstate them or otherwise, lost pay and benefits, and there can be double damages for any violations that are found to be willful. And there's some statistics there, just stating quickly that about 15%, and this I think is from 2018, not super current, but pretty much a general trend, 15% of complaints involved allegations of regarding to reinstatement or reemployment, and 62 were regarding discrimination and other more general allegations based on military service. And the next slide, we're going to talk quickly about resources. So the Department of Labor website, tons of amazing resources about guides and fact sheets, posters that you can post around and provide to employees. There's also a very helpful organization called the Employer Support for the Guard and Reserve, the ESGR. Their website provides resources. They have a lot of events. They actually provide mediation services upon request to help resolve potential issues without going through the court systems, which can be a great resource. And they have a hotline that you can call, both the employers and the employees, for guidance around complying with USERRA, the idea being that their goal is to make everyone be on the same page and try to resolve things and support this collaborative relationship. And then lastly, both these organizations also have different recognitions and awards. It's in a way for service members to kind of highlight their employers who have supported them and assisted, and it's a way for an organization to demonstrate their willingness and support of their service member employees. And it can be a great way to also attract other service member employees and to just have a little good PR on both sides. So a good incentive and a lot of good resources out there. And thanks for my quick overview on USERRA. Back to you, Andy.
Hey, Mara, thank you so much. In a question I know we're going to get about the slides, just like we do each week, these slides will be available and published on our website along with a recording of the program. These slides that Mara prepared are a great resource. I encourage you to print them out and keep them handy. The cases that I see involving USERRA typically involve an employer who's just not aware, very simply, of these requirements. So this is a very helpful resource that you can keep at your disposal. And the only other thing I would add is, Mar, just to say thank you for your service. Thank you for keeping us safe and protecting us. And I'm glad to have you as a colleague here at Bond. So thanks for joining us.
Thank you, Andy.
You bet. All right, next up, it is my pleasure to introduce Steph Fedorka and Dave Ferrara, two of my friends and colleagues here in our Syracuse office and our labor department. They're going to talk to you today about some interesting developments dealing with the workers' compensation law and COVID-related issues. So without further ado, Dave, Steph, take it away.
Thank you, Andy, for having us on. It's great to be here and talk about a little bit about the workers' comp world and what we've seen with COVID litigation. Next slide, please. So I think it's a good place to start with some of the legal theories that we've seen. I think we may have covered this early on in the pandemic. There was a lot of concern about what would happen if employees in the workplace were exposed or contracted COVID-19 in the course of employment from a coworker, from the public, again, in the course and scope of doing their jobs. So there was a lot of concern early on. What we've seen in the past 2 years, we've seen claims for tort, negligence, mainly breach of contract. Public nuisance has been a creative cause of action from plaintiffs' lawyers as well, attempting to circumvent the workers' compensation system and trying to bring lawsuits against employers for damages resulting from COVID-19 sustained in the workplace or COVID-19 related injuries or the illness itself and longstanding things. Some of the things that have been alleged mostly have been the failure to follow local, state, and federal guidance regarding COVID-19 and allegations that an employer didn't take the adequate measures to protect employees. Next slide, please. So a little bit of the background, workers' compensation, there's this principle of the exclusive remedy. Each state will have specific workers' compensation laws, so it varies, but the general rule is that if there's an exclusive remedy for work-related illness or injury, which is the workers' compensation benefit. So if an employee is injured or becomes ill from a work-related illness, right, it's work-related, it was contracted in the workplace, then they have to go through the workers' compensation system in order to receive benefits of some sort. They are barred effectively from bringing a lawsuit in state or federal court. The keys here are that it has to be work-related, right, arising out of and in the course of employment. And it's this principle of a quid pro quo bargain for wage and medical expenses paid to the individual employee. Some exceptions, again, vary from state to this general exclusivity rule. And some of them are failure to obtain and maintain workers' compensation insurance. So if an employer does not obtain or maintain workers' comp insurance and coverage, then an employee could bring a lawsuit in state court or federal court, right? Intentional acts or intentional torts are going to be the big one that we'll talk a little bit about. Dual capacity, which are going to be cases where, for example, a manufacturing facility makes forklifts and the employee is working on a forklift at work that was manufactured by the employer. The employee gets hurt because of an issue with the forklift itself, a product's liability issue. That employee can bring the product's liability claim against the employer, even though they happen to work for the employer who happens to be the manufacturer. And then fraudulent concealment, which are situations where an employer may know of a hazardous condition or know of exposure. You see these in things like asbestos claims or other chemical exposure claims, and they try to hide the danger from the employees or the injury. Next slide, please. In New York, this is the exception that's codified in the workers' compensation law when it has been determined that a plaintiff's injury is the result of an intentional and deliberate act by the defendant or the employer or someone acting on behalf of the employer. And the defendant is not entitled to such immunity. So the employer is not entitled to that workers' compensation exclusivity. But the conduct has to be that's engaged in with desire to bring about the consequences of the act. Their mere knowledge or appreciation of the risk is not the same as intent. So it's a pretty high burden. In cases that we've seen where the exception has applied, where an employee is not barred from bringing a lawsuit, it's been one example that we looked at was a case where the restaurant owner punched an employee in the face or physically assaulted the employee, right? There was that intent necessary to go beyond that exclusivity bar. Next slide, please. In New York, we have this Palmer versus Amazon case that we wanted to highlight for you. It was a group of employees who sued Amazon for failure to follow local, state, and federal public health guidance during the COVID pandemic, which they alleged caused injuries and death to employees and their family members. So they tried to bring a lawsuit under New York Labor Law Section 200, which essentially is a codification of a common law duty to provide workers with a safe work environment. It's similar to the OSHA General Duty Clause. This was brought down in federal court in the Eastern District of New York, and the court dismissed the case. It said that the claims were preempted by the workers' compensation law, so it held that the exclusivity remedy here applied. And it also noted that the primary jurisdiction doctrine applied. So the primary jurisdiction doctrine is going to be a doctrine that gives courts discretionary authority to say, perhaps this type of claim is better suited for one of the administrative bodies, something like an OSHA, to handle before. So they have the discretion to either stay the action in federal or in court and stay the lawsuit pending resolution in that administrative body. Or they can dismiss the claim. So here, the court dismissed the claim and noted that it was probably better suited to be addressed by OSHA than the federal court. And with that, I will hand it off to my colleague, Dave, to cover the remaining slides on this.
Hey, Dave, just need you to unmute.
Thank you very much, Stephanie, and thank all of you for participating. It's nice to be back with you again, and happy spring. It's been long overdue, and I think we're all excited about seeing some sunshine. The issue that Stephanie's raised here, and I just want to back up and level set a couple points. You know, most of us probably on this call don't spend a lot of time in the workers' compensation arena. We have risk managers in some of the bigger organizations that probably focus more. Where we do focus is sometimes as HR professionals, we get frustrated when we think people are taking advantage of the comp system. And this goes back to the bargain that Stephanie mentioned, that for now almost 90 years, that bargain has kept employers out of court defending all of these various workplace injuries and illnesses. And to be able to successfully do that, the exclusivity clause that Stephanie mentioned has to be maintained. It is the pillar of that statute, at least from an employer's perspective. And as Stephanie mentioned, when COVID first hit, there was tremendous concern amongst carriers, amongst the risk management professionals, as well as HR professionals. What's it going to do to the rates? Are we going to be defending these cases in court? Are we going to have to document all the various precautionary measures that we had to take in order to help maintain health and safety for our workforce? So unquestionably, one of the most single biggest issues that's affected the workers' compensation environment, if you will, is the lawsuits that have started to come out as a result of the pandemic. The other point I want to make before addressing Say's Candies is simply this. What we're seeing is three different types of cases. And as Stephanie mentioned, plaintiffs' lawyers who are never shy of trying to be creative and pursue, some of these litigation, they're bringing the cases in three different categories. The first you'd expect, it's on behalf of the employee himself or herself who contracted COVID in the workplace. And of course, the test and the challenge there is, A, can they even establish that the illness was contracted at work? And then can they get by the exclusivity clause? And as Stephanie's mentioned, for the most part, the answer is to the second question, no. They've not been able to punch holes through the exclusivity provision, which is obviously a good thing for employers. The second group of cases falls under estates. So estates of deceased family members who were employees for the XYZ company, trying to establish wrongful death claims on behalf of their loved ones. And again, for the most part, these have been unsuccessful. The third group brings us to the Say's Candy case. And here, what you have is, you have employees bringing an action on behalf of her husband. So here it was it's a 2020 case. Manufactured candy, assembly lines working very close together, okay? And employees complained that the employer placed them in close proximity and did not adhere to various safety mitigation efforts to prevent the spread of COVID. And plaintiff lawyers argued that the employer knew, should have known, and it was foreseeable that there was a high risk of viral infection and transmission to other workers, and therefore created this undue risk, which infected family members, including Mrs. Say in this case, okay? And the allegation was you're also not following, as Stephanie mentioned earlier, the various guidance that was out there, which, as we all know on this call, changed not only daily, sometimes hourly, which just further contributed to the frustration that all of you had to endure as we went through the pandemic. All right, next slide. Unfortunately, Mr. or Mrs. Eck potentially brings home the virus, and Mr. Eck and her daughter contracts it, and Mr. ultimately dies. Okay, that's the fact pattern that we are facing in this case. The case was brought in California, which most of you won't deal with unless you have subsidiaries in California or other divisions. But it's a very, very concerning case, and we'll see why on the next slide. The court looked at the claims, one of general negligence, two of premises liability. You didn't maintain a premise that was safe from creating a viral infection to your employees, okay? Mrs. X sought damages for the wrongful death of her husband, as well as loss of love, care, comfort, etc., okay? The defendants argued, as you would expect, that first of all, there's an exclusivity provision, but under California state law, there's this what's known as a derivative injury doctrine. Think of it this way. If Mr. ends up contracting an injury as a result of Mrs. So the typical scenario is Mrs. either gets seriously ill or dies, loss of consortium, loss of social relationship. It's related to her illness. Trial court here said, no, this doesn't apply. Why not? Because it was a separate and complete injury. He ends up dying. So it's a separate injury, and this derivative injury doctrine does not apply. Next slide, please, Kathy. So when they conclude that the derivative injury doesn't apply, therefore the workers' compensation exclusivity remedy should extend and cover this injury, if at all. And the court said, well, this is an open question, okay? The derivative injury doctrine only applies where no separate injury is claimed. In this case, we have a separate injury, and that is the loss of his life. When this case first was published, there was a lot of concern amongst folks in the workers' comp area and risk management that it punched a hole, and a big one, through the workers' compensation exclusivity clause. It really did not, because the court never addressed the merits of the case and whether or not the exclusivity provision would bar litigation. Now, these cases are on appeal, similar, if I can have the next slide, as well as the Amazon case in New York, okay? There's a lot of concern because in the Amazon case, and Stephanie, you may have mentioned it, and I apologize if you did, but I think it's important to remind folks, that case is on appeal to the Second Circuit Court of Appeals, which is the circuit that governs cases in New York and the surrounding states. It's a very, very well-respected Court of Appeals. That decision ultimately could create, some real hurdles for the exclusivity provision, but it's too early to tell at this point. As far as the Say's Candy case, as this slide indicates, because it wasn't decided on the merits, there's still an open question, even in California, if the exclusivity provision of the workers' compensation statute will bar COVID-19 claims. Court also didn't address, did the candy company have any duty at all to Mr. or the daughter or any other third party? That'll be a question that'll have to be litigated eventually, okay? And it assumed, but did not address, was there a causal connection between the employer's negligence and his ultimate demise? Because obviously the link has to be, did Mrs. Zach bring home the injury or bring home the virus and he contracted it? So none of those questions were decided in that case. Next slide, please. Couple things to keep in mind, and they've been mentioned, and Annie mentioned the HERO Act, but don't forget the OSHA General Duty Clause. OSHA historically did not bring many actions under the General Duty Clause because generally they looked at it as we have to have a special standard specifically that addresses a certain circumstance. So unless they could find and rely on a specific standard, they rarely went to the General Duty Clause. We're a little concerned that in light of COVID and some of the developments that have happened, you need to be sure that your workplaces comply with the General Duty Clause. Similarly, with respect to the HERO Act, even though, as Andy said, the plans are now on the shelf, you still got to maintain the plan. You still got to issue copies of the plan to new employees. Don't forget that. Don't let your guard down. Employees still have whistleblower protection laws. They don't have to establish an injury. Retaliation are often a big claim, okay? So that's another avenue in which employees may seek restitution or claims against employers in connection with if they bring to your attention an unsafe work condition or a violation of some law or statute, and then some adverse employment action happens, they're going to potentially allege it was because of their protected activity. So I just wanted to remind you of that. And I think the last slide, if I might, yeah, I hope COVID's over. We all hope COVID's over, right? But more than likely, as we hear some rumblings out of Asia over the last couple of days, you know, we're going to see most likely another strand, at least according to the experts. So we've got to still have an ability to monitor and comply with federal, state, and local guidance. Because if you're not following that, or worse, you're not enforcing deviations from that guidance, you're going to open the door to one of your employees, again, trying to get around and circumvent the exclusivity provision of comp. And if you can avoid it all from the beginning, then obviously, regardless how these cases end up being decided on appeal, you're going to minimize the exposure to your employer. Finally, please don't forget to communicate with your general liability or your owner's insurance policy, whatever may be the case. Because if for some reason there's a claim that does get out from underneath the exclusivity provision, you may have protection or coverage somewhere else. So a tip to your risk managers, be vigilant with respect to putting clients on notice. I just had another case just last week where the initial demand came, it didn't get to the right person in the company. It was set aside. The carrier wasn't put on notice. Now the case is being sued some 6-7 months later. And of course, you know what the carrier's position is. We've been prejudiced by your lack of notice and therefore no coverage. Thank you. Appreciate the opportunity. We're going to continue to watch this litigation. Obviously, we're watching the Palmer case very closely, as I said, because of the impact that court could have on subsequent judicial decisions.
Great. Dave, thank you for that. Very helpful information. Steph, thank you as always for joining us, for all your work on this. And as many of you know, Steph has also been diligently following all things New York HERO Act. So thanks again for having your oar in the water on that. And I think the takeaway for me on this is, you know, the issues with exclusivity and workers' compensation coverage and making sure you have that protection is compliance with the requirements and guidance that are out there. We'll do our best to keep you on top of those issues as they develop further. All right, next up, it is my pleasure to welcome Anna Richards. Anna is a partner here in our Syracuse office who works on business and business-related issues. If you haven't had the pleasure, it's great to introduce you to Anna. And Anna's going to talk about a significant issue in her area and practice area. So great to have you, Anna.
Thank you so much. Happy to be here. So I'm going to briefly cover a new law. It's just effective February 9th, 2021, and it adds some significant protections to consumers that have contractual auto renewal provisions. And in enacting this law, New York is joining a number of other states that have more burdensome auto renewal laws. So, if you do have contractual automatic renewal provisions with consumers, this is one that you should be aware of. It only applies to subscription or purchasing agreements that are automatically renewed, or in the event that one continues until the consumer cancels the service. And it only applies to consumers. So those are people that enter into contracts for personal, family, or household purposes. As you can see on this slide, there are a number of exceptions as well. One thing I wanted to note too is that there is still a separate law that applies to contracts for service, maintenance, or repair to or for any real property with auto renewal periods greater than 1 month. And that's under the New York General Obligations Law, and that still continues and is not changed by this existing law. So the real property law is still on the books as well. And so there are a number of exceptions here, including security system alarm operators, service contracts for sellers, banks, certain financial institutions that would not be subject to this new law. And the next slide has a list of some of the key requirements. One is that the automatic renewal offer terms must be displayed in a more clear and conspicuous type than the surrounding text. So this means that it has to be a larger or contrasting type, font, or color, or set off from the text somehow with marks that call attention to the language. And if it's audio, it still has to meet this requirement as far as volume. Some additional requirements. The automatic renewal terms have to include a list of disclosures. One is that the subscription or agreement will continue until the consumer cancels. It must include a description of the cancellation policy that applies to the offer, a description of the recurring charges. And if there's any minimum purchase obligation, that must be listed as well, and in addition to the length of the automatic renewal term. And this next point is important to note and make sure that it's not missed. The business is required to obtain the consumer's affirmative consent prior to charging the consumer's credit or debit card. So an example is if there's a checkbox next to the renewal clause, that could work, but it can't be pre-checked. And if there's a failure to do this, it's considered an unconditional gift and the consumer will not owe anything in that event. Some other requirements are that there must be a post-purchase acknowledgement that includes the automatic renewal terms. And there must be, if the offer includes a free gift or trial, it has to be a clear and conspicuous explanation of the price that will be charged at the end of the trial. And finally, for cancellations, the business must provide an easy-to-use, cost-effective mechanism for cancellations. For example, a toll-free number, an email address, or a postal address. Consumers that sign up for automatic renewal online have to be able to also cancel online. And that's important because I'm sure we've all seen circumstances where that's not the case, but you have to make sure that they can also cancel online. And the next slide has a brief description of some of the penalties. If there is a violation, the New York Attorney General has the right to seek an injunction and an order for restitution. In addition, courts can impose civil penalties, 100 per violation, or up to 500 for knowing violations, even up to 1,000 for multiple violations resulting from a single act or incident. And I also want to note that there is a good faith defense where businesses will not be subject to penalties if they show by preponderance of the evidence that the violation was unintentional and resulted from a bona fide error, despite the business having reasonably adopted procedures in place to avoid such errors. So just quickly, there are a few takeaway recommendations from that it makes sense to be aware of. One is that businesses should review their automatic renewal offer terms and their acknowledgement language just to make sure it meets all of these new requirements. In particular, make sure that you evaluate the display characteristics, including the size and the font of the disclosures, especially if this is on an app. That's something that's sometimes missed when you have a mobile app. The font and the size still has to meet those requirements. And in order to make sure that this good faith defense is available, make sure that you document all compliance efforts. If it ever came up, you would be able to show that this standard was met. So that is all I have for you today on this, but of course, if there's any questions, I'd be happy to answer them. Thank you.
Yeah, you're welcome. And thanks again for joining us. thinking of something that happened over the weekend. We changed our live TV streaming services, and with it came, a free package of another service that I was streaming. And I was excited at this, went to cancel that other streaming service and found that it was an annual renewal, right? So it just renewed automatically the month before. So I'm guessing that's the kind of thing that this is targeted at, right? To make sure that consumers at least are aware of what they're doing.
That's right. Yes, that's right. And
a little too late for me, I guess, or I missed it. But that's helpful. Thank you. We appreciate it. You bet. All right. Last but not least, certainly, it's my pleasure to welcome Kevin Cope. Kevin Cope, he works in our litigation department in our Buffalo office. He's an associate there. I think this is his first time joining us on the webinar, but it's great to have him. And he wanted to talk to you today about some of the insurance coverage issues that employers continue to face here in the COVID era. So Kevin, welcome. Great to have you. Thanks for being here.
Thanks, Andy. Great being here. So if you go on to the next slide, a lot of businesses have started to question in terms of COVID-19, all of these governmental orders that have effectively shut down businesses, whether or not business interruption or business losses caused by COVID-19 are covered within their business insurance policies. Unfortunately, if you want a short answer, the answer is no. The longer answer is it depends. And the reason for that is because there are two types of clauses that insured companies have sought to gain coverage under that courts have largely interpreted as not covering losses caused by COVID-19. On the next slide. So these two type of clauses, one is called the business interruption clause, and that's probably the most well known to you. It's where there is some interruption in business because of some external force that causes either lost profits or lost income due to that physical interruption. The second type of clause is the civil authority clauses, and each of those have been analyzed a little differently, but in any event, both have come out to the same conclusion that losses are not covered under COVID-19. Next slide, please. For business interruption clauses, the typical language covers two types of losses. One is additional business expenses caused by a loss or damage to real or personal property, and the second is general interruption of business caused by loss or damage to real or personal property. The courts have looked at both of these types of clauses and largely found that they require some sort of direct physical loss, which COVID-19 is not considered a direct physical loss. Without this direct physical loss, there can be no claim for business interruption insurance due to a government shutdown in the wake of COVID-19. Next slide. And the rationale for this is largely based upon the fact that COVID-19 is a virus that can be eliminated through what courts have called routine cleaning and disinfecting, largely what businesses might do nightly when employees leave by going through like a typical cleaning. We're just stepping that up a little bit and adding some disinfectant to that as well. It's not required to do some sort of in-depth cleaning to get rid of the presence of COVID-19 in a physical space. Secondly, these business interruption cases largely are based upon precautionary measures that are instituted by state government to prevent the spread of a disease. It's not necessarily that the disease is present on the property, but largely to prevent disease from spreading within that property. So that's been the rationale for denying it under the business interruption clauses. Some businesses might have what's called a virus exclusion under their insurance policy, and essentially what that does is it expressly gets rid of coverage for any damages caused by a virus. Courts have looked at that and have basically said that if that's there, it makes it a much easier case. There's no coverage, but some insureds have argued that the absence of a virus exclusion clause can create coverage, and courts have largely rejected that as well. Next slide, please. The second type of clause is a civil authority clause, and this is generally triggered when there's a civil authority, like a government entity, that prohibits access to a property because of loss to the property or something in the immediate area of the property. Like with business interruption clauses, these clauses have been deemed to require some sort of physical loss to the property in the presence of a disease might not necessarily trigger coverage. Next slide, please. They've also looked towards this and have said that the COVID-19 orders didn't prohibit access to the properties, however, they limited access to the businesses. And so long as the businesses could continue to operate in through any means, that there's no coverage under civil authority clauses. For example, in the Mangia Restaurant Corp case that's noted here, it was a restaurant, and because they could have operated in some means, they were not permitted to recover under the civil authority clause. Next slide, please. So looking at the statistics within the state of New York, 95.5% of all business insurance claims that have been filed have been dismissed, while 91.2% of all business insurance claims have, resulting from COVID-19 have been dismissed as well. So the vast majority of cases have been dismissed at motions to dismiss stages and haven't even proceeded to discovery. Next slide. And the longer answer is it depends, and that's largely because insurance policies are contracts and coverage is largely dependent on the language of the policy. For example, in the New York Botanical Garden case, which came out of the, I believe it was the New York County Supreme Court, the policy had language in there that essentially reduced recovery under the policy to the extent that the company could resume operations. And because of that language, the court found that a total shutdown was not necessary for recovery and allowed it to proceed to the discovery stage to provide some sort of potential coverage. Next answer, or next slide, please. So largely, it's an uphill battle. It requires close scrutiny of the insurance policy in order to determine if there is any potential coverage. So it is always a best practice that if you believe there is potential coverage under your policy, to have experienced counsel review the policy to see if there are any arguments for coverage. But you should act quickly because any claims under an insurance policy could be limited in the time you have to file it, as well as your cooperation with the insurance company. And that's all I have for you today. Thank you very much.
Kevin, thank you. Some really good advice for folks in there listening to this program when it comes to insurance. Just one quick note. As I look at this, I work with employers of all shapes and sizes. I think there's 4 relationships that are really key to a successful business or organization. Of course, your lawyers, right, who you work with on legal, your bankers, financiers, your accountants, but don't miss that 4th corner, right? Your insurance broker, your insurance agent. That relationship is absolutely essential. And I can't tell you how many times we've been involved in a case where there is liability or risk, and a client either says, I didn't know I had that coverage, and they do, fortunately, or I didn't know I could get that coverage, and unfortunately finding themselves in that situation. So Kevin, great advice for everybody. We appreciate it. You'll see everyone's contact information here on the next slide. We had an all-star lineup again here today. If you have questions on these areas, please reach out to these people. They stand ready to assist. In the meantime, please be safe, be well. We'll see you next week.